Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the new SEC guidance on cybersecurity disclosures. On February 20th, 2018, the SEC issued new interpretive guidance on public company disclosures related to cybersecurity risks and incidents. I've talked generally about the guidance and will now begin discussing specific areas of disclosure requirements. Obviously, where appropriate, cybersecurity risks need to be included in the risk factor section of any company's disclosure. The SEC guidance in this regard is very common sense. Companies should evaluate their cybersecurity risks and take into account all available relevant information, including prior cyber incidents and the severity and frequency of those incidents. Companies should consider the probability of an incident and the quantitative and qualitative magnitude of the risk, including potential costs and other consequences of an attack or other incident. Consideration should be given to the potential impact of the misappropriation of assets or sensitive documents and information, and the corruption of data or operational disruptions. A company should also consider the adequacy of preventative processes and plans in place should an attack occur. Actual threatened attacks may be material and require disclosure as well. As with all risk factor disclosures, the company must adequately describe the nature of the material risks and how such risks affect the company. Likewise, generic risk factors that could apply to any and all companies should not be included. Risk factor disclosures may include a discussion of the company's business operations that give rise to material cybersecurity risks and the potential costs and consequences, including industry-specific risks and third-party and service provider risks. The costs associated with maintaining cybersecurity protections, including insurance coverage. The probability of an occurrence and its potential magnitude. The potential for reputational harm. A description of past incidents, including their severity and frequency. The adequacy of preventative actions taken to reduce cybersecurity risks and the associated costs, including any limits on the company's ability to prevent or mitigate risks. Existing and pending laws and regulations that may affect the company's cybersecurity requirements and associated costs, and litigation, regulatory investigation, and remediation costs associated with cybersecurity incidents. A company also would have cybersecurity disclosures in its management and discussion and analysis section, or MD&A. In MD&A, a company should consider all the same factors that it is considering in disclosure of its risk factors. A company would need to include a discussion of cybersecurity risks and incidents in its MD&A if the costs or other consequences associated with one or more known incidents of the risk or potential of a future incident could result in a material event or has resulted in a material event, trend, or uncertainty that is reasonably likely to have a material effect on the company's results of operations, or on its liquidity, financial condition, or if such risk or incident could impact previously reported financial statements. The discussion should include any material realized or potential reduction in revenues, loss of intellectual property, remediation efforts, maintaining insurance, increase in cybersecurity protection costs, addressing harm to reputation in litigation and regulatory investigations. Further, even if an attack did not result in direct losses, such as in the case of a failed attempted attack, but does result in other consequences, such as a material increase in cybersecurity expenses, disclosure would be appropriate in MD&A. In the next and last LawCast in this series, I will finish discussing particular areas of disclosure. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.